All right, so we're going to talk about warranties today, warranties in subcontracts in particular. The reason that I want to talk about this is that it comes up pretty frequently, and one of the important things that I want to make sure that we discuss is the fact that there are some assumptions that most of you have about warranties that we need to correct and expand, okay? So two of the terms you're going to hear me use today are like express warranties and implied warranties. An express warranty, if I say that, if I slip into too much lawyerness here, an express warranty means a warranty that's written in the contract. It's actually there in words. It's expressed in the contract. The thing I'll spend a lot of time talking about is implied warranties, which means a warranty that you give by virtue of the fact that you've done the work, or that the general contractor gives to you, or that the owner gives, even if the contract doesn't say anything. These are just warranties that over time the law has said in the construction context, these warranties exist regardless of what may be agreed in any written document between the sub and the general and the owner, and so forth. And so because there are implied warranties in construction, I think it's important for you to understand them. I don't think that you're going to be surprised by any of them, but I think it's important that you understand them. Now, typically when I talk about warranties with contractors, or if I ask my clients about warranties, the comment that I get back is that, yeah, we give a 1-year warranty. And then the question I ask is, well, what does your warranty say? More often than not, the response is, well, it's not written down. We just warrant our work for a year. So let me kind of paint the picture a little bit to show you how that can be problematic for you. So if you say that you're going to warrant your work, you've got, generally speaking, 2 components to your work. You've got your labor and you've got your material. Does everybody agree with that? So if you're going to warrant your labor, then that means if it's necessary to come back and do some sort of work, then you're going to send employees out there. And as long as you've got a workforce for the warranty period, then you're in a position to be able to furnish that labor to warrant the work that you've done. But then if we get to your materials, things get a little bit more difficult. Because your ability to warrant materials for a year depends to a large degree on the willingness of the manufacturer, the supplier, to stand behind the material. So if you've got a commitment in a contract or otherwise for a year, and that's going to cover your material, then you need to make sure that you know if you've got a supplier and or manufacturer who's going to stand behind that warranty with you. The other part of it that comes up in both contexts, but is also problematic when we're talking about the materials, is when does the warranty start? So more often than not, the assumption is on your end as a subcontractor that your warranty starts when your work's done. But if you haven't read your subcontract clearly, it's possible that there could be some warranty language in there that says that it's going to be warranted from a certificate of occupancy or from substantial completion or something like that, which may occur after you're actually done, so that makes it go longer. Or until owner acceptance. Does all of that sound familiar? The other problem that you can have, again, when we're talking about material, is that if the manufacturer is going to warrant a piece of equipment, and I've seen this come up in the mechanical context, like with air handlers and things like that, they're going to want to warrant it from when? Startup, right? Okay. And so if they're going to warrant it from the time they ship and it gets stored for any period of time, then even before it's going, even before it's installed, let alone started up, you've got it running. And if you need it to go longer, then they're going to want you to pay for an extended warranty, right? So the idea of the 1-year warranty is that does not exist in Utah law. There's nothing in the law that says contractors warrant their work for a year. That comes from the general conditions in the standard AIA owner general contractor agreement. So it's sort of assumed within the industry that you warrant for a year, but that's because it's in those AIA general conditions. So that's where it comes from. But it's at the same time, even though it's not in the law, that's sort of the industry understanding that you'll warrant for a year. So with that discussion, then does that make sense to everyone about some of the things that you just need to be mindful of when you're thinking about warranting the work that you do and making sure that you understand the distinction between your labor and your materials and what you're going to get from your supplier and your manufacturers so that you know exactly what your commitment is? Because you could find yourself in a situation where if you don't have a manufacturer or supplier who's going to back you up, that you're going to be out of pocket on those materials or that equipment. Okay. Questions, comments, concerns? Yeah.
Comment, just something to note. We've seen this, we have a job that, okay, you got some material that came out of a job. Well, this is still good material, I'll just put it into this next job. You do not have any material warranty on that project if you did not purchase it from a supplier and have a ticket for that job. So
Yes.
I say, hey, this ball valve's still good, I can take it and I can put it over here, this job over here, don't do it. If that ball valve fails or a pipe bursts or something, you don't have any warranty from a manufacturer on that piece of equipment.
So taking a piece of equipment that you purchased for job A and using it on job B?
It was more, say, you did a demo and say, this pipe's still good. How many times have we done it? We got a piece of copper pipe. A copper pipe. Took it from here, you put it over there.
So it's a piece of copper pipe that you removed from another job?
Project, put it into another project.
Okay.
You don't have manufacturer's warranty. If something went wrong and you flooded that building, they trace that back. Where'd you buy that pipe from?
Yeah, so if you remove materials from job A and then install them in job B, I agree the manufacturer is not going to back it. You've also got another problem, which is one of the implied warranties is that your materials are going to be new, not used. And it's fairly common, I don't see it in all subcontracts, but I see it more often than not, that there's actually a specific statement, an express warranty, even though it's implied by law, that all of your materials will be new unless otherwise. So just by bringing it in and installing it, you're breaching that warranty. And yeah, you're not going to have a manufacturer stand behind you in that situation. The other thing would be if you had anything that was spec'd for job A, and for whatever reason it doesn't get used, so it's not installed, but then you bring it over to job B because you figure it's going to work here. And if the manufacturer knows that it was spec'd here and it's just kind of put in over here because it'll probably work, you could run into a situation too from a manufacturer backing that up. All right, any other comments before I start moving on? Yeah.
You run into a problem where you put in your equipment, pumps, air handlers, whatever, and the general comes in and say, hey, it's winter time, we want heat. And so you're in this area where you make the general mat and the oil mat and or your warranties started.
Right.
And so by the time you get done with the project, your warranty's up. Can you legally go to the owner and the general or one of them and say, this is when the warranty starts on this day?
Yeah, well, not only can you, but you should. So if they ask you to start up the heat and the job's not done, and that's going to commence your warranty on that equipment, then you should let them know that the warranty is running on that. The reason you should let them know is that you should assume that they are assuming they're going to have a warranty from whatever your contract says, if your contract says it, or if not, then essentially substantial completion or owner acceptance. So that's what they'll be operating under, those facts. If you let them know that by starting that up, then the warranty on that piece of equipment for whatever the term is, whether it's a year, 6 months, 180 days, whatever you got. Let them know that that's going, and that if they want it to go longer, that they're going to need an extended warranty, or whatever the manufacturer is going to require, if they'll even warrant it for that much longer. You need to do it in that situation, because if you don't, then they'll throw it back on you.
You need to have a signed document?
No, you need to be able to demonstrate that you told them and when you told them. It can be an email, just something that you can document so that you can show that you let them know. And then if they come back and say anything, then you can say, hey, sorry, I told you this was what was going to happen. So here.
But they come back and say, well, no, right in your contract it says this.
That's why you let them know. That's part of letting them know, is to say, okay, my contract says this, but because you asked me to start the equipment, the manufacturer's warranty will begin when that does, and unless someone pays to extend it, and we didn't put an extension in here, we didn't build that cost into here, so we're not going to pay for an extended warranty. Now, a common response that you could get from a general contractor would be, well, you knew this thing was going to be, we'd be working here in the winter and we'd need to turn it on for the heat. So, if you have something, if you have like a standard bid condition or statement in your bid about not running equipment until the project's complete or anything like that, it's all about you'll see in here when we talk about it a little bit, a lot of the idea behind the warranty and who's going to have to warrant what is who is in the best position to be able to prevent the problem. And so you want to make sure that that doesn't come back to you. So what you do is you let people know where the problem is, so then it shifts to them to be able to deal with it.
The problem with moving those before the job's finished is all the construction debris gets in there.
Right.
It's valid, which wouldn't happen if you did it apples all together.
Yeah.
That's the
Right. Yeah, no, I've seen that on more than one occasion where you get all the dust from the sheetrock and yeah, all those things that get in there and mess it up. That's why they want you to pay for an extended warranty in those situations. In fact, I have seen situations where I've had clients go and ask for an extended warranty and the manufacturer has said, no, if you're going to run this during the construction process, we're not going to extend the warranty. This isn't designed to function in that environment.
exactly.
So, yeah, that's a tough situation. Any other questions before I move ahead? All right, so if you look at the first page of the materials, what I laid out here is it says the basic assumptions in the traditional design and construction process. So it's from these assumptions that these implied warranties that I mentioned to you arise. So the first one, number one, is between the contractor and the owner. So the contractor, the general contractor, or if you're dealing directly with the owner, is going to assume that the owner will provide a design adequate for the owner's purposes. Do you guys always get designs that are adequate for the owner's purposes? Never a flaw in a design? Cooperate with the contractor in performing the contract and disclose information material to the contractor's performance. That last part, a lot of times what you're talking about there especially is like site conditions, underground conditions, geotech type of things. So if the owner knows about it, that they disclose it so that the contractor has an understanding of it. Cooperation, the duty to cooperate is in any contract, but especially prevalent in construction contracts, and that's not just between the contractor and the owner, but also between the contractor and the subcontractors. So then number two, the owner and the architect. The owner assumes that the architect or engineer will prepare a design suitable for the owner's purposes and requirements with reasonable care, skill, and diligence, meeting the standards of their profession. So that works into the warranty that the architect or the engineer makes, that what they've done is sufficient for what this is intended to do. And if it's not, then that architect, whether their contract says anything, or that engineer, whether the contract says anything or not, has breached a warranty to the owner. The owner, number 3, the owner assumes that the contractor will construct the project pursuant to the design with reasonable diligence and in a good and workmanlike manner. That's standard. There's an implied warranty in every construction contract that you will do the work in a good and workmanlike manner. What's that?
Meet all the codes, right?
Yeah, code. The meeting of the codes is part of what's in workmanlike, but it's also like your skill. It's the way that you do the work. So it's not the end product, but it's the manner in which you do the work throughout the process that you're involved. So it's code, state and federal law, all of those things flow into that. Yeah.
What's the difference in like quality of contractor versus a good quality of only when you get this like buyer beware sort of thing where, you know, you're assuming this warranty is going to be good work and quality. Yet you hire the low down dirtiest cheapest contractor to build your house, and he's got a reputation of being horrible. What's all that?
Yeah, okay. So instead of going with someone who's reputable, you just hire someone who's cheap. So that doesn't change the fact that the cheap contractor still has an obligation to do the job in a workmanlike manner. They still have to perform the work that way. The risk to the owner is that even though the person they hire has an obligation to come and to fulfill their responsibilities in a good and workmanlike manner, doesn't mean they will if they don't know how to, are too lazy to do it, or just can't do it for any other reason. So the law puts the warranty there, but the risk to the owner is that by bringing in someone who's cheap, then they've got a house or whatever portion of it is done by someone who does cheap work.
And enforce the warranty a lot more than quality.
Yeah, so now you've got, what do you want? You want the job done right the first time, correct? And so the owner has the opportunity to make demands, and if it can't be done and they hire someone else to fix it, then to go and get it, but that's not really where the owner wants to find themselves. So that's where the caveat emptor part comes in, which is that, hey, the law says that they have to do it in a good and workmanlike manner, but if they don't, you got it, and you got to deal with it. And maybe this person's not in a position to be able to, quote unquote, make you whole. So, is that?
The old buyer beware, so.
Yeah. Okay. Number 4, the owner, designer, so engineer, architect, or anyone else who's involved in design, contractor and supplier. The owner and the design professional and contractor assume building materials furnished by the manufacturers or suppliers will be of merchantable quality, which means that they're fit for their intended purpose, which is what it says right after that, and that they will be furnished with the information for proper use. So that's like your O&M manuals and stuff. Then number 5, the owner and the design professional assume the contractor will seek clarification of any obvious deficiencies in the design documents. That's true between the general contractor and the sub. Notice it says obvious design deficiencies. It doesn't say every design deficiency. So if a deficiency is obvious, then you've got an obligation as a subcontractor to do an RFI or to get some sort of clarification on it. Now, what obvious means is in the eye of the beholder, but ultimately, if you think it's obvious, then you need to get it clarified. And then the last one, each party assumes that everybody else will act in good faith and will cooperate to avoid hindrance, interference, delay, and timely completion. Now, you take that, and I don't know if all of you are aware of this or not, but there is an implied warranty from the owner. That there are two major implied warranties from the owner. The first one is that if the owner has any scheduling requirements, if they've got a date when it needs to be complete, then the owner warrants, whether they say it or not, that the work can be done according to their schedule. So if they say, job must be complete by this date, then there is a warranty from the owner to the general contractor, and that flows through to the subcontractors, that the work can actually be done within that time period.
Reasonably. Is that what you're saying?
Yeah. So if you run into problems that are going to delay it of whatever type, then the owner's got an obligation because of their warranty. They've warranted that it could be done on that time. Now it becomes evident it can't be done on that time, in that amount of time. So that warranty works back to an obligation on the part of the owner to do a couple things. One would be to extend the deadline. The other would be to incur the expense for additional forces to be able to get it done by that deadline. The other warranty that you get from the owner is that the owner, whether they say it or not, warrants that the project can be built according to the plans. That the plans, if you follow the plans and the specifications, you will be able to construct the project appropriately. That's called the Spearin Doctrine. That goes back to a case where the United States Navy hired a general contractor called Spearin to build a dry dock. I think it was in Norfolk, Virginia. And so they were following the plans. They had excavated the area for the dry dock, and then there was a storm. Well, as a result of the storm, and prior to the storm, they had gone in and they had rerouted a sewer. Well, what nobody knew, and this was in the early 1900s, what nobody knew is that there was another sewer line farther up that wasn't shown on the plans that the Navy knew about that fed into this sewer that had been rerouted. And there was some sort of a dam in that sewer. That dam, because of the storm, was overwhelmed. And so an unanticipatedly large amount of sewage came into the rerouted line, which wasn't capable of handling it, and the dry dock was flooded with raw sewage. So that slowed things down, as you can imagine. So they had to get that all taken care of. They had to go in and they had to figure out what to do with that other sewer and take care of that. They obviously had to clean out the construction area. That cost time, that took money. And the Navy said, too bad. Spearin said, we want some more money. The Navy said, no. Look, you're building it. That's force majeure. That's an act of God. It rained. And they said, no, it's just really lousy plans. I was going to say crappy plans, but I stopped at the last second. Sorry. I'm not even going to get a couple of courtesy chuckles on that one. Oh man, this is going to be a long one. I can see that. All right. Sorry. This is law. There's only so much we can do to make it interesting. All right. So Spearin said, no, it's the plans. You should have shown it on the plans. Went all the way to the United States Supreme Court. The United States Supreme Court said, too bad, so sad, United States Navy. Spearin followed the plans. They can't go and guess stuff that's not there. So your plans were inadequate. And so Spearin was compensated for that. So that's what's known as the Spearin Doctrine. So as a result of that, then we could spend a couple hours talking about a lot of fine points in that case and how it fits in different design contexts and things like that. The long story short is this, that the owner warrants the plans to the sub and to the supplier that they're adequate, that they're sufficient, and you can do the work based on the plans. As a result of that, if problems arise because of defects in the plans, that goes back to the owner. Okay. Now, if you go down to, there's a header that says application of the UCC. UCC stands for the Uniform Commercial Code. The Uniform Commercial Code is the reason it's called uniform is that it's the same. So there's an organization that began creating the UCC, I think it was back in the 50s. And so the UCC there are 10 articles. Article 1, 2 is the one that this talks about. Article 2 is called sales, it deals with goods. 2A, which is leases. I won't go through the others. So there's 1 through 9. But most, if not all, of the UCC, particularly this article, Article 2, have been adopted by all 50 states. The idea behind the UCC was for there to be some uniformity of law across the states so that people would be able to have some predictability to the rules. Well, within the Uniform Commercial Code, there are 2 implied warranties. The one that comes up that you deal with the most with your suppliers and your manufacturers is called the implied warranty of merchantability. The implied warranty of merchantability means that anything you buy is fit for the intended purpose. It's supposed to do what it's intended to do. And if it doesn't, then you go to your supplier, they go to the manufacturer, and it works back to wherever the problem was in that process. That's the implied warranty of merchantability. Here's the reason that you need to know that. Number 1, that's a warranty that comes to you without anything being said. It's just created by this law. Number 2 is the subheading down there that says disclaimers of implied UCC warranties. Very, very frequently, the manufacturers and suppliers will disclaim the warranty. So there will be something in the materials that says that they disclaim any and all express or implied warranties, including the implied warranties of merchantability and fitness for a particular purpose. You've probably all seen that, but you may not know that you've seen that. So either on the packaging, or if it comes with any materials that explain it, somewhere within there, they have to put in the disclaimer. And the disclaimer has to be conspicuous. So usually they capitalize it. That's the standard of practice, is that if you're going to disclaim the UCC warranties, you may have a paragraph, and then in the middle of the paragraph it says, disclaims any and all express or implied warranties, including what I just said. That's how you know you've seen it. So if you see that, then that means that they're not going to stand behind it if it doesn't do what it's supposed to do. And if it's your expectation that it will, and that they're going to back you up if it doesn't, then you need to get a hold of them and understand what they're going to do to stand behind it. Because whatever document that's written on, it was written by their corporate attorneys. And so the manufacturer may feel like they do want to back it up. So they may give you something that says, no, we'll back it up or we'll stand behind it. Or you can have your supplier talk to them or get something from them that says, hey, we just put that in all of our stuff because our attorney told us to, and he wrote all that stuff in there, but we'll take care of it. Questions about that? So that is something that you will see frequently with products. And we're not just talking about construction materials, but you see that frequently with anything, because the Uniform Commercial Code, Article 2, which is what that's talking about, it applies to goods. Goods are considered to be anything that can be moved. So if you can move it, it's goods. And the Uniform Commercial Code applies to it. All right. Let's go to then typical express warranties. These are things that you will commonly see in your contracts. I don't think anything is a surprise there, so I'm not going to spend a lot of time on it. The first one, title to the work and materials and equipment will pass to the owner no later than the time of payment, free and clear of all liens, that the work will comply with the contract. Another one that's really common, like I said, is that everything's going to be new. And then you've got manufacturer and supplier warranties that I've talked about, so I'm not going to spend a bunch of time on that. I want to get down to the implied warranty, because this is where I want you to be really mindful of I don't think, like I said, you're going to be surprised by it, but I want you to make sure you understand that these are commitments that you're making just by virtue of the fact that you're doing work. So the first implied warranty is what we've talked about, that contractors and subcontractors are going to perform their services in a workmanlike manner. Now, I've mentioned this a little bit, but I want to make sure that you understand how this applies. This is what's called an in-process warranty. Most warranties are the end result. You warrant something, some condition at completion. The good and workmanlike performance warranty is an in-process warranty, which means that throughout the process of construction, you are warranting that you will do the work in a good and workmanlike manner. So at least in concept, at any time that you are not doing the work the way that is expected of a licensed professional in your situation, you're breaching the warranty. So it can happen at any time in the construction process. Does that make sense to everybody? So from your first day until your last day, you are doing the job in a good and workmanlike manner each day. So you can have some defect issues that come back in. Really, it gets more to the idea of the skill of the person who's doing the work. But just know that that's a commitment that you're making every day that you're on the job. Next one, number 2, applies in residential construction, and that's the implied warranty of habitability. Now, before I talk about this very much, let me step out for a second and just give you a little bit of background about what's going on in some other states that we're not seeing in Utah because of some changes that got made to the law about 10 years ago. So, in Oregon, Washington, Nevada, as I understand it, I'm not sure, I think California to a certain extent, but it may have gotten fixed legislatively. What happened is that you had judges that were coming in and applying the UCC warranties that I talked about to construction. Here's why that becomes a problem. That's because essentially houses were being treated like products. And so you would have a lawsuit that would get filed, and more often than not, this would be if you had a uniform builder in the subdivision. So the builder is doing every home in the subdivision. And then you'd have some defects in the homes. The place that it started in most states was with stucco. So what they convinced the judges to do was to bring in all of these theories that apply to the UCC that really shouldn't deal with construction, but the courts agreed to go ahead and do it. So the builder would get sued. Then the builder would sue all the subcontractors, and so on. And so you'd have these huge, huge cases with multiple subcontractors represented by multiple attorneys. Florida, this was huge down in Florida in the 90s and early 2000s. It would trigger your insurance, so you'd have insurance counsel in there. and you'd have these massive lawsuits. Well, the whole idea behind it is that plaintiffs' attorneys, like, you see Siegfried and Jensen, Robert J. DeBry, those guys really just negotiate insurance settlements. So what happened is some people figured out that contractors have insurance, so let's figure out a way to sue contractors so that their insurance companies will settle with us, because insurance companies have a tendency to treat a lawsuit just as like a business transaction. So that was the reason that this all got started. So there was a law firm out of Portland called Vial, V-I-A-L, Vial and Fotheringham. Have any of you guys ever received any letters from Vial and Fotheringham? All right, so they opened up an office in Salt Lake about 10 or 12 years ago. And their stuff had kind of run its course over there, and there were some other lawyers that were doing it. So they figured Utah was a land of milk and honey to start these ideas. And so they began trying to convince courts here in Utah to do things that had been done in some of the other states. Well, that got noticed, and so there were some changes made at the legislature to keep those concepts from finding their way into Utah law. So as a result of that, Vial and Fotheringham ran a test case. They've done 2 test cases to try and challenge that statute to the Utah Supreme Court. The first one they lost completely. The second one they kind of regrouped, got their ducks in order a little bit more, went back up to the Supreme Court. The Supreme Court shot them down again with the exception. So the Supreme Court said Utah does not recognize all of these implied things that you're bringing in. That's products. These are buildings. The only thing that the court said, the only implied warranty that they gave to the owners and acknowledged in Utah law was number 2, the habitability of the residence. So this applies in residential construction. And basically what it means is this won't come as a surprise to any of you. It means that when a house is finished, it's inhabitable. It means that you can live in it. So the builder has warranted that the house can be lived in. That's not too bad, right? How many houses get built that you can't live in? Most of the time, if you look at cases where habitability is a problem, you've got mold issues because there are problems with moisture in there for whatever reason, whether it's leaky plumbing or there's or from some other source, especially when you get into some of the more humid states, there are issues that come up. The other thing is just like major structural defect so that the house is condemned, which we don't see too often. Another that can show up here in Utah, but we don't see a ton, but it does happen, is earth movement. So if people didn't pay attention to geotech and you get the house in and it's on a hillside and it starts to move, that can bring this up. So as long as it's inhabitable, as long as people can live in it, even though there may be some concerns they have, and there are plenty of times when people will try to turn every construction defect into some sort of a habitability issue, but it's not that broad. It means that you just flat out cannot live in the house. So that's the extent of what those guys have been able to achieve here in Utah. So we haven't seen too many problems with that, which has been good. The reason it's good is that it keeps your insurance costs down. In some of those other states, like Florida, Washington, Oregon, and so forth, contractor insurance rates are substantially higher as a result of the courts adopting those things. Does anybody have any questions about habitability and stuff like that? Okay. Well, when the builder gets sued, then what they do automatically is they just sue every subcontractor. Have you ever seen those shirts? I don't know if they're probably still out there. It's like, it says Special Forces, shoot them all, let God sort them out. Okay, well, the plaintiff's attorney's theory is that it's like, sue them all, let the judge sort them out. Does that make sense?
So you do a $10,000 job on a $500,000 house.
Yeah.
What do you get sued? $10,000?
Well, maybe the house is moving because the sewer's leaking.
Good point.
So there has to be some connectedness back to the problem, but it can be fairly extreme. But usually what you'll see initially is that all of the subcontractors will get named. And then they'll go out and get some experts, start digging down into what the real problem is, and then they'll let people out. Part of the reason that everybody gets named is that it goes back to your insurance. And so they figure that even if you're not really responsible for it, your insurance company would rather write them a check than spend a bunch of money to defend it. And so the more people that you have named as defendants, and this is why contractors have become targets in these states, is because not only are contractors insured, but you got a lot of insured people working on one project. If you have a car accident, you have a car and a driver. So how much insurance is that going to give you? But if you can get 20 defendants in a lawsuit and each defendant kicks in $10,000, now you got $200,000. So that's the other reason why.
Is that
Yeah.
something that's currently in our liability insurance, or is that something that have to get certain?
There's a whole theory of law that applies to this called negligence. It's part of what we call tort. That statute that got put into the Utah Code took basically the decisions of four decisions from the Utah Supreme Court, going all the way back to a case called American Towers Homeowners Association versus CCI Mechanical. Don't know if you guys know the whole story with American Towers. But the Utah Supreme Court said in that case that in construction, we use contracts. We don't pay attention to this other stuff that's called negligence. Those four cases are what these attorneys were trying to get overturned by the decisions they were bringing from other states. So the change that got made at the legislature, which prevents that, was that unless you have property damage, so it's something besides the building, it has to be damage to something inside of it, like a car or to clothes or to your bed or your furniture or something like that. Unless you have property damage, personal property damage, or injury to a person from whatever the defect is, then you have to go back to the contract, which means the owner can't go to every subcontractor directly and sue them. They have to sue the builder. And the builder has to bring in all the subs. Dave and then Kevin.
I'm in a lawsuit right now, which is, I know we're getting off the warranty a little bit, but I'm in Daybreak.
Yeah.
They sue Holmes Hall and they sue another builder, so the homeowners association,
Right.
because the roofs leak and the exteriors leak. And so Holmes doesn't want to defend themselves against all that, so they bring in 40 subcontractors.
That's exactly right.
Absolutely nothing to do with those leaks.
That's right.
But my insurance company spent $190,000 so far in the last 2 years representing me for something that's not even my fault.
Yep.
My insurance went up $18,000
No.
because of it. That's just bullshit.
No, I agree with you. Yeah, I'm generally familiar with what you're talking about out there. And that's exactly the situation that we're talking about. So, yeah, Kevin.
What about a time frame on that type of stuff? Is it?
Yes, so you got a 2-year statute of limitations with a 7-year statute of repose. So what that means is that the lawsuit has to be brought within 2 years. But if the problem wasn't evident within those first 2 years and they don't discover it until later, then they have 2 years from the time they discover it. But once you get to 7, over completely. Yeah.
Not just have to worry about holding our breath for a year, it's now 7 years.
Well, that's a negligence claim, remember? So that's only if you have, remember, you have to have personal injury or damage to personal property. So a person has to have physical injury. Sometimes it's called bodily injury. So the types of cases that we're talking about with that 2 year are actual physical injury to a person as a result of the problem or damage to their property as a result of the problem. So usually the reason that it would be longer, be in between the initial 2 years and the 7, is that, yeah, so it's like since you guys are all plumbers, you have some joint that fails because of some inadequate design at 5 years. And you have all this flooding and all of the stuff in the basement, all of the mementos and everything like that are completely lost and ruined. So since you haven't hit 7 yet, and that defect wasn't visible, it wouldn't be known, then that's where it comes in. It's things like that.
Now, isn't there something that insurance companies are trying to change the contract so they want a better basis? For what our agent was telling us, I need to reach out to you about this. They're trying to basically make the warranty last for life.
The insurance companies want the warranty to last?
Yeah, there's some weird clause they're trying to change up here. I can't remember exactly what it was.
Yeah, let me know.
But they're kind of freaking out over their contract. They're seeing it, it's coming down from the bigger guys first, but they're trying to make it basically own that building for the rest of your life.
Huh. Yeah, I would have to see that to get an understanding of it. Dave, did you have something?
Statute repose.
Yeah.
Tom, repose. So in some cases it's 9 years, is that correct?
Yeah. They're not all 7, but yeah.
So you're saying that no matter what, you have a responsible for warranty for 7 years?
No, this doesn't bring up warranty. This is negligence. So no, negligence is 2 years with the statute of repose. So what it means is if there's a defect in construction that results in injury to at least one person or damage to somebody's property that's not the building, then
A house settled that actually broke a pipe in a house after several years.
yeah.
And they tried to come after us, and like, how can you be less responsible if the house settled?
Right.
I don't understand that.
Yeah.
And it passed inspection, it lasted so many years, and then, what? You think it just rotted out? I mean, the house settled,
Yeah.
it's obvious.
Well, yeah, so when the house settles, you didn't do the geotech, right? You didn't do the,
Not on this one.
you guys do a lot of geotech? Shamrock's in the geotech business? Yeah, it's not really your problem. But like I said, I mean, that's the situation that Dave's got. What does he have to do with siding and a leaky roof? He plumbed the house, right? So,
We got a case the other day for a job we did in the brewery 4 years ago, that somebody slipped and fell on Thanksgiving, and so now they're trying to come after us because for improper installation of a floor drain. How's that like?
well, you have an injured person. You have an injured person. So there's, one of the things you have to understand is with negligence that the United States Supreme Court made a decision back in the early 80s that lawyers could advertise because advertising is protected as commercial speech under the First Amendment. Before that decision, then the ethical rule for attorneys was that a lawyer shall not seek work. It was unethical to quote unquote seek work. After that decision from the United States Supreme Court, that's when you saw the proliferation of advertising. And most of the advertising that you see is negligence-based. And so as a result of that, so now, you know, you look at the mid to late 1980s until now, and you have all of this advertising, there is a perception within our society that if someone's hurt, it's somebody else's fault. That we never do anything to put ourselves in a situation to get hurt. So if we're hurt, it's got to be somebody's fault. And that's how you get a circumstance like that, which is that somebody slipped and fell. Well, it was somebody's fault. Maybe it was the person who was walking and they weren't paying any attention. But
So is there a possibility that they could come after them for that?
yeah. I mean, if they're sending letters, making demands,
Came from our insurance, so we turned it over to the insurance company.
yeah.
Told them to go deal with it.
It's a bad deal.
But it's ridiculous, water on the floor, proves that that's.
But remember, if it's been 2 years, if say it's been 4 years, and if the condition was not a latent defect, which means hidden, then it's past the statute of limitations. Number 3, suitable construction. That's just another way of saying workmanlike performance. 4 is clarification of the plans. This is one you've got it. I've mentioned it before, just that the concept's there, but this is your warranty. If there's an obvious defect, that's where this applies. So what this means is you got to look at the plans, which I'm not saying you don't, but the law is telling you you need to look at the plans, because if there is an obvious defect in the plans, you are warranting by doing the work, by undertaking the work, that you are reviewing the plans, that you will identify obvious defects, and you will ask for clarification on those defects. So if you don't, and then there's a problem later, and you come back and you say, well, look at your plans. I mean, it's obvious in your plans that we couldn't do that, then you're going to be in a tight spot. Now, that doesn't mean that you need to meticulously go back in and redesign the project, but it has to be something that would stand out to you. So you have to review it with enough care that you could identify whatever is obvious that's not there. The next one, number 5, is sort of an extension of that. Actually, I take that back. It's not. The next one, number 5, is also, it can fit in with the plans, but it also fits into the in-process part, which is that if you become aware of a code violation, this includes by you or by anyone else, some other error or defect in your work or in somebody else's work, that you are going to let the owner and or the general contractor know about that. That make sense?
Is that in writing? You need to
No.
do that.
That's it. Oh, how you tell them about it?
Yeah, that's why you can prove the.
Well, yeah, there's, you know, the rule is that the most paper wins. If you didn't say it, it didn't happen. So it doesn't mean that every contractor has to like be a cop on the project and report everybody else. It's not like a tattletale sort of a rule. But if there's something, if it's especially if it's going to affect you, you want to make sure that people know about it, because you don't want to come back with some sort of back charges and problems like that later, right? So if you see something that's going to affect you, you definitely want to make noise about it. But then the other part is, if it's even not affecting you, but there's something that's very, very clear that's a violation, then you need to let people know about it. But it's going to have the most impact on you if it's going to affect your work, because there's the possibility that if the problem gets discovered later, then you just get sucked into it in some way. So on the owner, the first one is the suitability of the plans, which I already told you about. And then the second one is the schedule, if the owner mandates the schedule. Now, let me say something about the suitability of the plans, just because it's in there a little bit. How often how often are you engaged in some portion of the design process? So instead of design, bid, build, there's some element of design build that comes into your work. Whether you sub that out to an engineer or you make some decisions on your own, how frequently are you involved in the design process? Very frequently? Okay. So because of that, the law creates this balance between the degree to which the owner's got responsibilities for design errors and the contractor or subcontractors have responsibility. And what it falls down on is what we refer to as design criteria or performance. So if the owner gives you a specific design criteria, so if they give you information that whatever you're designing has to achieve, and that criteria turns out to be insufficient or problematic, that's on the owner. But if it's considered to be a performance criteria, which means that it's just as part of the work that you do, you need to do it in a particular way, then it's on you to make sure that you do that. Now, I realize that's kind of vague, but that's how the courts divide it, is between design criteria and performance criteria. So if it's the way that you do it, that's on you. If it's the object of whatever you're designing, that's on the owner if there's a problem there. Is that clear as mud? Or is it? So if you're doing something, if you have to do some design work, then you're going to have responsibility for your design except for any design aspects that are mandated by the owner that your design must achieve. I don't know if that clarified it or not. And if those design objects prove to be like insufficient, inadequate, defective, or something like that, then the chickens come home to roost in the owner's barnyard. So I'll give you an example. I have a case right now up in Washington where I represent an electrical subcontractor. They did the design work on some student housing at Washington State University. They designed it on the voltage that they used ultimately turned out to be insufficient. It's acknowledged that that the engineer that they hired, which if I said it, some of you would recognize the name, that they made some calculation errors when they designed the system. But the owner added a bunch of stuff to the apartments, including plugs for electric vehicles. That's going to take a little bit more power, right? So a big part of the dispute is that it's acknowledged if the engineering subcontractor says if the building would have been constructed as intended without all the stuff that the owner added, even with our mistakes, the system would have been adequate. The owner says no, that's not the case. So we'll see where that one ultimately lands. It's going to be another year and a half or so before that gets done. But where the owner brought in all of those additional things, and those electrical vehicle plugins aren't the only thing, but they're a big part of it because they do draw a lot of power. Then to the extent that's a problem, then that's going to fall back on the owner. So does that help illustrate it a little bit? All right. Does anybody have any questions? Yeah.
You find the prints are, this isn't going to work. Okay, it doesn't meet code, or it's not gonna perform like you think it's gonna. You write the RFI, every time we write an RFI, we have to give them the solution. Does that make us the designing contractor, even though we're just telling engineer, hey, this is the solution to your problem? If you don't, the answer, you get the answer. And you're just like, well, what am I going to question? So, at what point do we become the designer by giving them a suggestion?
At the point that the court decides you're the designer. I can't give you a bright line on that.
So you have a responsibility to correct the print. Or
Yeah.
offer the correction for the print. But you're putting yourself at risk by offering the correction for the print.
If the, that's what I was just going to say. Yeah, so you're coming to the engineer and you're saying, this is what we think needs to happen. But in the end, it's the engineer's decision. So if the engineer signs off on it and says, do it, now the engineer has endorsed that. And if there's if your idea that the engineer accepted doesn't work, then really it's the engineer's problem, because that's why you went to them with the RFI in the first place and with the information that you gave them. And then it's their job to say, okay, I hear what you're telling me, and yes, I think that will work. So to be able to make the whatever magic the engineer does to decide that you're right, in the end, that's the engineer who's going to have that responsibility. But that doesn't mean that they'll agree with that. Any other questions?
We had a project, and we wanted to flip the job from a heat pump job to a VRA.
Okay.
Calculations were there, the supplier worked with me, everything was fine. All right, you need to hire an engineer to sign off on this. Hire the engineer, we pay the engineer. The product manufacturer didn't stand behind his equipment like he should have. He became responsible for paying the replacement of 7 or 8 compressors. He wouldn't stand behind it. The general contractor said, well, you're the design build contractor.
Yeah.
Because you paid the mechanical engineer.
That's right. That's correct.
So my recommendation is that comes up, you say, architect/owner, you pay the engineer. I will give him my information, and he's to review it, because I am in no way taking liability for the design. It's the engineer, I'm not paying.
Yeah, if you hire the engineer, then the engineer is your subcontractor. And as between you and the general, you are the designer. And so if there's a problem, then the general points the finger at you and you have to go point it at your engineer. That's the same thing that's going on with this student housing. So yeah, when you hire the engineer, if the only thing that you do is hire the engineer and pay the engineer, you are the designer to the person who you have contracted with. So, yeah. Yeah, they've got their tricks of the trade too. So the purpose of our discussion today is not for me to chase you guys out of the business. I mean, a lot of you guys have heard the saying, and I repeat it all the time, small-time gamblers go to Vegas, big-time gamblers get into construction. Dave, I think you told me that like 15 or 18 years ago or something, and I've been repeating it ever since because it's true. But what I want you to do is the purpose of this is to give you information and understanding, not to scare you out of your businesses. Really, if you think about what we talked about, it's fairly common sense. It's fairly straightforward. It's just as much as anything to be able to help you make sure and recognize the potential risks that you've got and how you can address them. Like I said, on the waivers, on the disclaimers, keep an eye out for that, especially on big items of equipment. So if someone's disclaiming it, you get clarification there. The other one is make sure that when you review your subcontracts, look for things that you're saying, commitments that you're making, because if you make a commitment, if your contract says everything will be new, then everything needs to be new. Now let me give you a cheery note here, all right, before we finish, to leave on. I think you're all aware, especially in commercial construction, how one-sided the subcontracts are. Is there anybody who's not of that opinion? All right, so I'm going to be in an arbitration all next week. Part of our objective is that this isn't going to like go out on the internet between now and the end of next week, okay? Because I don't want my litigation strategy known to an attorney down in Phoenix. But a big part of our strategy is to use the subcontract against the general contractor. So let me give you some examples. The contract said that all material needed to be new. They're refusing to pay my client, who's an excavation contractor, for the general hired someone to come in and they just dug up a bunch of stuff in the road, and so some of the manholes got ripped off and things like that. So my client bought new ones and installed them. The general contractor said, hey, a lot of those you could have just used. So they're refusing to pay the new cost because they said you could have reused some of those things on the site. Our response is, you told us we warranted and we have an obligation based on your contract to use new stuff. The other thing we've got is they've got some back charges that are in there that are based on periodic expenses, but they didn't show up until the end of the job. That should sound familiar to everybody. Our response on that one, which we think will be successful, is that if you're going to back charge us for your water truck watering every month, then you should have been sending us an invoice each month so that we would know. So think about that on back charges. If you get a back charge that comes back to you, and the back charge represents charges that should have come to you really each month, because how often do you submit a pay application? Each month, usually by the 25th of the month in a commercial setting, right? Sometimes the 20th. You're expected to bill each month. If they're going to back charge you, and they're going to save all those back charges to the end, but those are cumulative of several months, then the response is that you had an obligation to let me know. That's an implied duty in all contracts, which is to mitigate damages. The other thing we're doing, if I can remember it, oh yeah. So we have another big charge where they brought another subcontractor onto the job. That subcontractor messed up a bunch of stuff. A bunch of water got loose, flooded the sewer lines, or the storm drain lines that my client was putting in. The general contractor is refusing to pay for those. Well, in the subcontract with my client, it says that the work cannot interfere with other contractors. So our response is that, look, you told us that you wanted us to be careful so that what we did didn't interfere with other people and create problems for other people. Your subcontractor, now you're on the other side of that, cut loose a bunch of water out of this broken pipe that flooded and put a bunch of debris down into the storm drain that we had to clean out, and it cost $40,000. So that was your sub, who they should have an obligation not to interfere, just as we don't have an obligation to interfere with each other. So you're responsible for their interference. So what we're doing is we're trying to turn that contract back as much as possible on the general contractor to put them on the hook for a bunch of the problems we had, and then fighting back on their back charges. So we'll see how that goes, and if it works out, then maybe some future Thursday night at the association, I'll let you know how successful we were. But that's the strategy we're using, which is turn the subcontract against the general contractor, because they're written by their lawyers. Most of the people on the job don't know what's going on, so we figured we might as well try to use it against them as much as possible. Now, I want the association to warrant that this will not go out until my arbitration's over next week. We got that? Okay. All right, thanks. I hope that was helpful. If any of you have any questions, I'm happy to talk to you about it. But that's all I've got, unless you have anything more for me. So thanks.